Hello, everyone. Welcome to this week's updates of immigration law. I'm proud to have my law partner, Aaron, who is the Director of Removal Defense and Family Immigration. And we're going to talk to you about a lot of things that happened this week. I think foremost on all of our minds is the situation in Afghanistan. It is a crazy situation over there. There are citizens, permanent residents, as well as civilians, Afghani civilians who assisted the military through translations and intelligence throughout this conflict, this decades-long conflict. And we're literally talking thousands and thousands of people. So welcome, Jennifer. Welcome to the stream. We're just giving everyone an update on Afghanistan. The first thing that I would like to tell you all is that there are a number of public resources that you can access to find out information about how you can help out with Afghanistan and the situation in Afghanistan. If any of you are interested in assisting, please let us know and we will email you those resources, but they can be found on aila.org, AILA.org. And that is where you can go and find out how to help in many, many ways. Our office is engaging in parole requests, humanitarian parole requests for those who are in the country or who have family members abroad. I'll be honest with you, there is a process for the parole request, but anecdotally, we don't know what or how what's going to happen. If that's approved, what does the person do with the parole request? You know, now that there are explosions at the airport, it sounds like it's going to be harder and harder to get people out of the country. So it's a process that we're learning every day. We're sharing information as we get it. But if you have family members or loved ones in Afghanistan who need assistance, please know that we are here and we will do what we can to help out. Aaron, another huge update, kind of ping pong, I would say, is what's going on with PD, the world of PD. So tell us a little bit about what's going on with prosecutorial discretion.
Right. So prosecutorial discretion is basically inherent in all law enforcement. And I always like to think of it like this. If you're a police department and or if you're a police officer and you're standing on a corner and you're looking across the street and you see one person jaywalking and you look the other way across another street and you see another person robbing a bank, who do you go for? Well, you use your discretion to let the person jaywalk probably and not get in trouble, and you probably go after the bank robber. And that's prosecutorial discretion. And so law enforcement agencies decide which laws they want to enforce and to what extent, basically to prioritize the use of their limited resources. So this has existed forever. And under the Trump administration, they said that the priorities weren't going to exist. Basically, they were going to try to deport anybody who was without status who they could deport. And everybody was a priority. The Biden administration came in and said, no, we're going to delineate some priorities and decide how we're going to use our resources. And they did that early in their administration. They were sued by a number of states led by Texas. And one of the judges in Texas entered an injunction, basically saying you can't enforce that enforcement priorities memo. And everybody was wondering, well, what the heck does that mean? What does that mean for prosecutorial discretion? And the decision of the judge was stayed first by the judge himself and then by the Fifth Circuit Court of Appeals. So the injunction is not active right now. And after this little bit of a roller coaster of a week, the ICE offices or the ICE attorneys have confirmed that they're continuing to accept requests for prosecutorial discretion. And what can that look like for somebody in removal proceedings? Well, you could be requesting to administratively close your case, so basically indefinitely put your case on hold, or to have your case dismissed, or to have them agree to relief in a certain case, to grant your applications. And so that's all back on. They're considering their requests. I'm preparing one right now, actually, for submission hopefully tomorrow. And so that is good news in the short term, but we'll have to continue the roller coaster as the litigation continues. But for now, prosecutorial discretion is back on.
It's alive and well for the moment. What do you anticipate, Aaron? Do you think that this case will go up to the higher courts? And if so, will there be a stay? What can we anticipate as next steps?
Well, there's kind of two separate questions, because will the injunction go up, and will it be upheld by the Fifth Circuit? Maybe. I think we're going to maybe talk about my MPP program in a minute, and that was actually upheld by the Fifth Circuit. The injunction was, and the Supreme Court declined to get involved and to grant a stay. And so after that shocking development, I wouldn't be surprised if they did something similar for the injunction of the priorities memos. That said, the judge does not have the authority to enjoin prosecutorial discretion as a concept, as a thing. It's those specific priorities in that specific memo that he's enjoining. And so even if there is an injunction that's in effect, the agency has the authority to exercise discretion on a case-by-case basis, just considering all the totality of the circumstances, and offer prosecutorial discretion as they see fit, just without reference to that memo that's been enjoined. And in fact, that's kind of what the ICE attorneys have done now on their website. They put their guidance back up on their website, but they stripped out all of the references and reliance on the priorities memos from early in the administration. They basically just list out some factors and say, we're going to look at these on a case-by-case basis. And the judge isn't going to have the authority to enjoin those. So my expectation is prosecutorial discretion is going to continue uninterrupted, even if those those priorities memos are enjoined going forward.
Awesome. What about, Jennifer, let's bring you into the discussion. This week, there were some updates also on medical exams and what we need to get in order to get a medical exam. What's the update there?
Yes, so it was just announced that beginning October 1st of this year, anybody applying for lawful permanent residence or for a green card is going to have to establish that they have a complete COVID-19 vaccine. So whether that's, I don't think they've said I think it can be Pfizer, Moderna, Johnson & Johnson, like whatever is accepted in the country of vaccination, but you just have to be complete. So for Pfizer, for example, you have to have both shots. And this isn't a huge departure from prior policy for the medical exams. There's already a list of vaccinations that people are required to get, like the MMR, the measles, mumps, rubella, polio, tetanus, hepatitis B, like just some examples. And so basically they're just adding COVID to that. And it's going to apply at USCIS, so stateside applications, and also the Department of State, so applications abroad.
Do we know if those are going to happen prospectively, like if you're filing for an adjustment of status after that date, or what about pending applications? Do we know?
I think it's going to apply to everyone. Let me see.
I think it's October 1st and after, okay. I believe, but that's a great question. We should probably look in. I'm looking here. It says on the CDC guidance, the instructions in this document are to be followed for COVID-19 vaccination among applicants for all countries and are effective as of October 1st, 2021. So I take that language to mean maybe that you don't need it if it was before, but we'll see. I mean, I think it's a really good question.
Yeah, it looks like, so what I'm reading, it says starting October 1st, green card applicants who attend their medical examination without proof of the vaccination will experience delays in their case processing. There are, and I didn't want to get too much into this, but there are waivers if there's like medical contraindications, religious reasons, things like that. But obviously you would need to speak to an immigration attorney about that.
Well, we talked about the migrant protection protocol, so let's give a little bit of an update here. There's actually, this to me is actually kind of frightening, what's going on with the migrant protection protocol. So as you recall, when the migrant protection protocols were happening, there was a FOIA filed and there was a bunch of eyes on the border because, if you remember seeing it in the media, the migrant protection protocols were the tent courts, right? They were literally holding people in tents and conducting their hearings in these like tent courts on the border. And there was a lot of exposure. And as a result, after the elections, after President Biden was elected, DHS began the process of unwinding the migrant protection protocol, and individuals who were in Mexico at that time were permitted to register for a process that allowed them to, who were subject to give them more due process and fairness considering their immigration courts. And in June of 2021, DHS expanded processing for people and allowed people for in absentia orders of removal or cases that were terminated to also register. And we weren't sure, there was no indication of how they were going to proceed with these categories of people, but that's what happened. And then ultimately, there was the government sought to, or not the government, the state sought to stay the implementation of this unwinding of the Migrant Protection Protocol, and it wound itself all the way up to the Supreme Court. And this week, yesterday, August 25th, the Supreme Court refused to stay the lower court ruling that would require the reinstatement of the Migrant Protection Protocol. And so basically what happens is, the Migrant Protection Protocol is basically can go back into place now. And obviously, I'm concerned because, the impact that this may have, the decision of the Supreme Court, the impact that may have on future policy decisions of the court, because, they basically just refuse to stay it. So big problems. We have yet to see what's going to happen as a result of the unwinding of MPP, but we will keep you posted. Stay tuned for next week on that. All right, let's see. Let's talk a little bit about immigration reform, because there was big news this week on immigration reform. So as you recall, a couple weeks ago, we talked about the fact that the reconciliation budget included about $100 billion to support a legalization program for Dreamers and TPS applicants, essential workers, and other immigrants, right? And so what happened with that reconciliation package is, because it was part of the budget, it didn't require as many votes. It only required a simple majority to pass through the Senate. And then it went to the House, and the House passed it on yesterday. So now that it has passed both the Senate and the House, it will now go to committee for a determination. It's actually going to go to the Judiciary Committee of the House and Senate, and they're going to draft language that's basically implements what the Senate and House have asked them to do. And then it'll come back to the House and Senate, and it will be voted again. We anticipate that will be sometime this fall. So what that means for you is DACA holders, TPS holders, guest workers, people who are in H-2B and H-2A. This is going to be a massive, massive legalization program. And we anticipate that as early as fall. Now, every time this happens, every time we get news of a major immigration reform, unscrupulous lawyers, crooked lawyers, and notarios come out of the woodwork saying, give me your money and I will give you legalization. You need to understand that there is no program right now. If people are telling you that they pay me and I will help you with immigration reform or get you to the front of the line, that is nonsense. There is no line, there's no process, there's no procedure. Don't be swindled. On the other hand, when you hear about it, in Las Noticias or whatever you watch, because it will be big news when it finally passes, get on the phone with us, because we can help you through whatever process is going to happen. So please do look out for it. Tune in every week to our updates, and stay tuned for when it's going to happen. All right, let's see what else I wanted to talk about this week. Another one on the business immigration side is that the H-2B cap was reached finally this week. So the H-2B cap, it was really interesting how this worked, because what ended up happening is there was numbers set aside for when they added numbers. They set aside a certain amount of numbers for the Northern Triangle, for the essentially Central American countries. And the problem is that those Central American countries didn't use all of those visas that were set aside for the the Golden Triangle. So at the end of the day, because those visas weren't used, the 6,000, they went back to returning workers. So if you'd been counted at any point as an H-2B in the past, I think it was 3 years, you could apply for an H-2B. And finally, yesterday, we reached the cap on H-2Bs. So no more H-2Bs for this fiscal year. That being said, we're already beginning the process of getting ready to file for the next part of the fiscal year. So if you want H-2Bs, you should be contacting us now for January 1st start dates. Or I'm sorry, April 1st start dates. All right. I think that's all that I wanted to talk about on this call. Do you all have anything else that you wanted to add before we get to some of the questions? Anything else we wanted to talk about? Anything big that happened this week?
No,
Feels like a ton happened. Well, let's get to questions.
I was going to say, I actually saw a question and it relates to the COVID vaccine. It was about if AstraZeneca is accepted. And so it looks like any of the vaccines that are accepted in the United States, so Pfizer, Moderna, Johnson & Johnson, but then there's also a World Health Organization list of other vaccines that are accepted for emergency use. And so if it's on that list, it can also be used. And I believe there's 2 AstraZeneca vaccines on the list available on the WHO website.
Awesome.
So, yeah.
All right. What about EB5? So as you know, the EB5 program was not reauthorized. When I say the EB5 program, I specifically mean the regional center program. So this is the $500,000 investment in a pre-designated USCIS regional center. Congress, that is a program that has to be reauthorized by Congress every year. It's not statutory. And so they let it sunset. And where the question is, when is it coming back? And we know it will come back. It always does. But the question is when. Normally that happens in September. So I would anticipate sometime during the month of September, EB5 will be reauthorized. In the meantime, those EB5 applications, I-526s, I-526s, and also I-131s and I-765s and I-485s, green card applications, work authorization, advanced parole, and the actual I-526 are on hold. So stay tuned. We will let you know as soon as we hear anything about EB5 reauthorization, but for the moment, it's completely on hold. I'm going to pull this one up because we do have a little bit of updates on K1 stuff. Aaron, do you want to talk about Judge Boasberg and what we heard from him this week on Kinsley and Milligan?
So
If you want me to do it, I can.
No, you go ahead because I haven't read all those updates yet.
Okay, so as you know, we're sort of in holding pattern, waiting for a decision on Milligan and Kinsley. Okay, Milligan is the K1 massive lawsuit challenging the refusal to issue K1s worldwide at the consulates. That's the Milligan case. The Kinsley case is a challenge to the proclamation broader across all visa categories, immigrant visas and non-immigrant visas, and challenges the use of the proclamation to ban the issuance of visas worldwide. Those cases were both assigned to the same judge. And this week in the Milligan case, Judge Boasberg asked both parties to submit a status report. And in that status report, he asked both parties to indicate which plaintiffs are remaining in the lawsuit, where their cases are pending, and how long they've been pending. Okay. We take that as an extremely good sign, right? Because what it means is he's grappling with this mandamus issue, right? He's grappling with whether there's been a delay and whether he can make a sort of universal order on mandamus. So it's good news. It means that the decision is coming soon and that the judge is considering it. On the Kinsley case, he also asked for a status report, I think it was yesterday. So it sounds like we are going to get a decision probably on the same day in both of these cases addressing these issues. So good news, Judge Boasberg's out there and he's asking questions and we hope to have a decision very soon. I also wanted to show this. I told you that there's ways that you can assist with Afghanistan evacuation. Here's the website here. It is in the chat box. So if you're interested in helping out in any way, there's a huge amount of resources on this website that you can use to help in any way. All right, I already talked about the update in Kinsley. Let's go to here. St. Luke's in Manila, which is where we have to do the medical, just had a bunch of their staff quit, which will probably hurt interviews because I'm guessing if you can't do your medical, you can't do the interview. This is a problem. This is the first we've heard of this. If your medical exam is expired, that's correct. Does the expansion of medical exams, this would not impact them, the 4-year extension of medical exams, would it? I don't think so because it's only new filings. So unfortunately, yes, this is something we're going to have to communicate with Joe Carrilli. So Mike, if you will send me your information and your fiance's information, as well as your case number, your NVC number, and the proof that you have of this, then I can send this on to Joe Carrilli, because this is going to be a problem, a huge problem. And we'll want to let the judge know about this as well. So thank you for bringing that to our attention. As Mike Follison said, give us your news source, because we can't just allege this. We want to make sure that we have backup for it. This is definitely your question, Aaron. Once again, the question we get every single Facebook Live. Yeah. When are we going to get it? When are we going to get an order from Judge Mehta?
At the beginning of the week, I said that that I was hoping that this was going to be the week, and we're almost to the end of it, but not yet. Yeah, I expect a decision any day. Do I know that that's going to be today or tomorrow or before August 31st? No, I don't. And in some ways, not in all ways, but in some ways, the longer it goes, the more I wonder if Judge Mehta feels comfortable letting it go longer, because he knows he's going to reserve a lot of visas. And so the deadline's not going to be as impactful. So that's a positive way to look at it. But no, I expect it any time. And the fact that Gomez came down means, to me, it means he's basically considered all the same issues, and he should just have to tailor a decision to the Go case. So hopefully soon.
All right. Patrick, have I had any communications with U.S. Attorney Carrilli regarding Ramirez v. Blinken? Yes, I absolutely have. Let's see, what day was it? On August 20th, I emailed Joe, and we had gone through and kind of done a deep dive into the data that we had based on what you've reported from Milligan and Ramirez. Okay. And if you base it on what the government has submitted to the courts, then it seems to be, for the most part, with a few exceptions, that they are going in first out order. But they use the word documentarily complete in this chart, and then there's a whole bunch of dates, right? And so that's what they're using in terms to sort of target or lock first out order. The problem is we don't know what that means. We don't know when Joe and the government is considering a case documentarily complete. And so it's hard to say whether it's in first out, because what they're determining may be different from us. It's also confusing because, normally people don't provide documents to NVC. And so when they say documentarily complete, it's sort of confusing to what they're determining. So here's what we were able to determine from the data. First, in round one, we had 10 plaintiffs processing out of Manila, and all 10 have been resolved. They were resolved very quickly, and it seemed like initially they were prioritizing adjudication of K1s, regardless of when they were documentarily complete or when they were marked documentarily complete. We had clients as late as August 2020 in round one that were adjudicated. Now, Ramirez has 139 plaintiffs, and only 21 have had interviews scheduled or visas issued. And from our data, it does look like they're going pretty much in the order of documentarily complete, although not entirely. There are some 2019s that have not been interviewed. There also is a case where the embassy granted an expedite request, but for other plaintiffs, they've processed most of the cases considered documentarily complete as of mid-February 2020. We have 23 plaintiffs in round two of Milligan, and only one has had an interview scheduled. However, the majority of them are marked as documentarily complete after mid-February 2020. So, if you go by their dates, they seem to be going in order. So what that shows us is originally there was movement with Milligan plaintiffs in Manila. And then something happened, but it doesn't appear that there's any disparate treatment now between the round two plaintiffs and the Ramirez plaintiffs, because only one has had an interview scheduled in Milligan and only 21 have had an interview scheduled in Ramirez. So hopefully that helps clarify things. That's the data we have. Again, that's based on what you all are reporting in the spreadsheet. And it's based on Joe's records from what he had and what he claimed as documentarily qualified. Let's see. Okay, Aaron, here's a question we get frequently also. Will the order in Go be only for plaintiffs, or for everyone?
Yeah, so Osama, I think this question comes up a lot, and so the way that Osama phrases it is, how could Judge Mehta how could he make an order that's not for plaintiffs if the case is only for plaintiffs? It's not a class action. Well, my first response is we very simply and repeatedly requested that the relief be that the Go plaintiffs be set for interview given the delay, and have their visas adjudicated. So that's the relief we've asked for. If you want me to talk theoretically about how it could not be for all plaintiffs, then I can. The judge has all kinds of powers, and he can make an order that doesn't necessarily force Department of State to adjudicate cases with very high numbers, but says that those which would have otherwise been adjudicated in random order by this point need to be adjudicated or reserved. So the judge has all kinds of powers, and me speculating about exactly how he's going to frame or craft the order, I just don't know. But we've asked for the relief for our plaintiffs, not for anybody else, just for our plaintiffs.
So we know how the order came down in Gomez, right? Do you anticipate, or do you think that the position of the Go plaintiffs is different, or do you think that we can use that as some sort of guidepost?
I mean, I think it's a helpful guidepost. I think it shows how the judge considers it, but there are some important differences here. In Gomez, there's a certified class. For DV 2021 cases, no case has a certified class. There is no class. And so that I would think would impact the way that the judge crafts relief. And secondly, another difference is that the Go case is set for it's briefed on motions for summary judgment, which is a final decision, whereas the other cases are in a more preliminary posture. Whether that ultimately matters to Judge Mehta, I'm not sure. But there are certainly differences between the way Gomez played out in our case.
Sort of a related question is, we won Gomez. The judge said, I told you to reserve visas a long time ago. You haven't done that. You haven't processed any of them. So now I'm ordering you to issue the visas, right? So we're in this period of negotiation with the government about how that's going to happen, right? How are we going to adjudicate these 9,000 visas? Aaron, you've been involved in that process. How do you feel about the government and their what they're doing in terms of negotiating on this issue?
I mean, to me, it's remarkable. The government litigates this case for over a year now, loses the case with the judge finding that they unreasonably delayed the DV 2020 visas, ordering them to go ahead and adjudicate the...
Wait, let me stop you, Aaron. We can't get into specifics about the discussions with the government, but so don't talk about specifics, but maybe kind of the problems we're having with the government.
Yeah, no, I mean, just generally, and this is consistent with their position in the hearing, in the public hearing. They want the judge to let them start processing these visas in fiscal year 2023. That's what I find remarkable. To lose on an unreasonable delay case and then have the proposal to the judge be that we're going to begin to process the cases in fiscal year 2023, I just think is not something that's acceptable, and I doubt that the judge will think it's acceptable either.
Yeah.
Brandon Go here asks, what could that impact be for Go? Would the judge really buy their sob story? By sob story, I think he just refers to the difficulties that the government might mention in processing cases. Well, I don't know, because if the judge thinks that they're taking, again, an unreasonable position on DV 2020, will he be more likely to issue a more firm order and a more expeditious order, kind of slapping down the government and Go for DV 2021? Possibly. I don't know, but it's a good question, and it's going to be interesting to see how it plays out.
Yes. Another thing that the government said is in their status report. By the way, it is public. I forgot about that because they did file the status report, so we can talk about it now. It's not. There's an ethics rule that says that if you're negotiating with the government, you really shouldn't. It's confidential. You really shouldn't talk about the scope of the negotiation. So But it's been filed now, so we can talk to you about what's in the document. The other thing they're claiming is that their computer system can't be updated quick enough to process the visas.
Yeah, I mean, to me, what the government's position is in the joint status report is if we don't lift a finger to change anything, it's not possible for us to process these until 2023. And so, that's the whole point of the case. You need to change your procedures. You need to hire people who can switch up your software, reassign staff or hire more staff to make it happen because the delay is unreasonable. It's already been found. So get to work, chop, chop.
There's another thing I'm going to share my screen. I think I can do that for a minute because I would love for you all to see this. Let me take this down first of all. Let's see, share my screen. Share my screen. Okay. All right. I don't want you to see us because you already see us. But what I want you to see is this. Can you see it?
No.
Oh, shoot. I think it's because I'm on dual monitor. Here we go. Here we go. Let me do that again. I want this. I want this. All right. Well, let me just tell you about it. On August 23rd, no, I can do this. Wait, sorry. Let me do this again. Sorry, I can't do it. I just need to change my screen. Okay, here we go. Share. Okay, now I'm going to go to this. Can you see this now? Department of Press Briefing. All right. The Department of State issued a press briefing about Afghanistan on August 23rd. Okay. I would love it if you all read through this because there are so many beautiful nuggets in this transcript, including how accommodating the Department of State has been towards Afghanistan refugees. Not that that's a bad thing, but you know how they've been accommodating? They've been providing telephonic and video interviews. Also, in addition, not only have they done that, but they're also the headquarters, the people at headquarters in Washington, D.C. are the ones that are conducting these interviews. Not only that, but they're deploying consular officers from around the world to conduct these interviews. So all of a sudden, what we've been claiming and advocating for this whole time, that, you really can process these visas. You can do it electronically. Now we know they can because they've publicly come out and said it. So, any sort of excuse that, we're downstaffed, that has been rebutted by what's going on in Afghanistan. So to the extent that we're able to resolve this Afghanistan situation and move on towards the rest of the world, I think that we're gonna be able to use this evidence very much to our advantage. All right, let's see. Anything else over here? All right, assuming a positive outcome for reservations, any chance of negotiating an option for adjustment of status for reserves? For example, if a person comes and studies on an F1, could they now then switch to adjustment of status and use the diversity visa?
I wouldn't count on it. Maybe Jeff could think of some creative litigation to get you in, but I wouldn't count on it. The only defendant here is the Department of State, and so USCIS, who does the adjustments of status, isn't subject to any order that the judge is going to make. All
right, we already answered this question about prioritization of plaintiffs. This is a good question. Can we appeal a negative order? Like if we get a bad decision in Go, can we take it up to a higher court?
Yeah. I mean, we can appeal to the DC Circuit.
Yep, not a problem. All right, let's see. I think that's all the questions we have. Any final comments from Jennifer or Aaron before we check out? All right, then. Well, it was a busy week for not only Joseph and Hall, but for the universe of immigration. And so we'll stay tuned and check in next week, same time, same place. We'll see you then. Bye-bye.